Hereby I open this academic ceremony in which Senai Andemariam will defend the academic thesis entitled The Concept of Necessity in WTO Law, Lessons from and for the Other Fields of International Law. Dear candidate, may I invite you to present a summary of your study and the conclusions of your thesis.
Thank you, Prorector. Dear members of the assessment committee, friends, colleagues, and family members. In the coming 15 minutes, I will present my PhD dissertation and the key findings. In 2006, the International Law Commission observed that it is possible to maintain coherence in international law despite the increase in fragmentation in international law. It was also indicated in that report that fragmentation and coherence are possible between and among either different fields of international law or similar concepts that are found in different fields of international law but may have different meanings. And one of these concepts is the concept of necessity. In this dissertation, which is being prepared in the context of fragmentation and coherence, the exercise of finding coherence means examining whether such similar concepts can learn and borrow elements of definition from each other, and the term used in the dissertation is inter-influence each other, and achieve more harmonization through the process while respectively maintaining their unique definitions. Why pick the concept of necessity? 4 reasons. First, necessity has a very long history on many sides. This dissertation, for instance, traces the concept of necessity from the first millennium BC. There is an extensive and established practice of necessity in international law across many fields, and there is a potential to apply the already established concepts of necessity in existing and new areas of international law. And finally, the proximity that the concept of necessity has with other concepts such as force majeure, distress, and self-preservation. And this dissertation focuses on 2 of the concepts of necessity that have become well established, the WTO law concept of necessity and the customary international law concept of necessity. Why focus on these 2 concepts? The relative clarity of their respective definitions, their extensive applications in the respective fields of international law where they operate, the number of disputes that discuss these concepts, close to 120 disputes have been discussed in this dissertation, and their proven potential to influence similar concepts of necessity in other fields of international law. The research question, therefore, is can these 2 concepts of necessity, WTO law and CIL concept of necessity, influence each other to achieve a more coherent concept of necessity across different fields of international law? To do this, the thesis has been structured in this way. Chapter 1 focuses on the history of the concept of necessity. Chapters 2 and 3 try to establish whether there is a WTO law level concept of necessity, and at the end of chapter 3, the conclusion is that we have enough case law to conclude that there is what we can call a WTO law concept of necessity. And chapters 4 and 5 focus on concepts of necessity in other fields of international law, particularly the CIL concept of necessity. And then in chapter 6, the inter-influence exercise is conducted. So what's the essence of that exercise of inter-influence between WTO law and CIL concepts of necessity? The exercise is to first identify the similarities and differences between the elements of these 2 concepts of necessity and look for elements that can be cross-fertilized towards a more coherent concept of necessity that can be exported to other fields of international law. but the exercise needs to take some cautions, and 5 of these cautions have been identified in this thesis. The first caution is to carefully look at the way these concepts are formulated, because the history shows us, including the practice, that some of these concepts of necessity in some fields are presented as justification, others are presented as an excuse. Even within WTO law, some of these concepts are presented as affirmative defense, and in other fields of WTO law, necessity is presented as a substantive obligation. In some fields of international law, necessity is part of primary rule. In others, it is part of secondary rule of international law. Second, to ensure the existence of the basic similarities or common characteristics. Third, to look at the relationship between these 2 concepts of necessity that we're trying to synthesize, whether there is a lex specialis relationship between them, or whether there is a rule-exception relationship between them. This will help ascertain the possibility for inter-influence. Fourth caution is to ensure the possibility for these concepts to be alternatively applied in a given dispute. Because if one has a choice between, say, WTO law concept of necessity and CIL concept of necessity, then unless one conducts this exercise of harmonization or coherence, the risk is such that the consequences can be different. Therefore, one has to look whether these 2 concepts can be applied alternatively. And that is an encouragement to conduct the exercise of coherence. And finally, to conduct the exercise with the aim of avoiding conflict between these concepts. So what was the result of this exercise of inter-influence? So on the one hand, we have the influence of the WTO law concept of necessity to the other concepts of necessity in international law, particularly CIL. And these are the elements of the WTO law concept of necessity, which we call the weighing and balancing test. So these 4 elements are identified. And on the other hand, we have lots and lots of elements of the CIL concept of necessity. It has a very long list of elements, but of these 3 have been identified as the potential elements that can be cross-fertilized with the WTO law concept of necessity. And the exercise showed that 3 of the 4 WTO law concept of necessity elements can be cross-fertilized the other way around, and the 3 elements from CIL can also be used to further develop the weighing and balancing test. And this will take us to more coherence in the concept of necessity in international law. Therefore, this has generally been the trend of inter-influence between WTO law and international law in general. But in concept of necessity, the dissertation found out that WTO law has the potential to influence other fields of international law than the other way around. What are the key findings and conclusions, therefore? Necessity was initially, if you look at the history, understood as having the same meaning as, and often conflated with, the other defenses: force majeure, self-preservation, distress, in the practice of most fields of international law, including domestic law. But through fragmentation of international law, this process starts to change. And fragmentation of international law gradually led to having different meanings or presentations of the concept in different fields of international law, and this concept starts to be distinguished from the other defenses. Third, there is a strong argument based on WTO law case law for adopting, mutatis mutandis, the weighing and balancing test as the WTO law concept of necessity, because necessity is found in different forms in 17 of the many WTO agreements. So the analysis led to the conclusion that there is a high probability that this concept of necessity developed in the GATT and GATS can become the WTO law concept of necessity. Fourth, the WTO law and CIL concepts of necessity can be used as platforms to influence the development of concept of necessity in other fields of public international law. Once we synthesize these two, then the final result can be exported to the other fields of international law that are yet to develop the concept of necessity. Any effort to achieve coherence, not only in the concept of necessity, but in other concepts as well, should take care of the cautions that I mentioned earlier, and also recognize the natural inevitability of fragmentation. Sixth, in the area of necessity, the other fields of international law can be more influenced by the concept of necessity in WTO law than the other way around. And finally, this exercise has shown another proof that WTO law does not operate in clinical isolation from public international law, and that is the wish of the early members of the appellate body. And this is, I believe, a pictorial representation of what this dissertation is. So each concept of necessity has its own color, its own shape, its own beauty, but once you synthesize them and put them in their proper place, then you can have a bigger picture of necessity in international law. Final slide. What are, in my opinion, the key contributions of this thesis to the scholarship? The first one is systematically digging into the long evolution of the concept of necessity, not only in international law, but also in select domestic laws, with special focus on GATT, WTO law, and I referred to the conceptual history, examination of text, discussion of state practice, tribunal practice, and analysis of case law. Second contribution is identifying the possibility for extracting a WTO law concept of necessity out of the texts of WTO agreements and their case law. Third, examining whether the concept of necessity in different fields of international law can inter-influence each other in the broader context of fragmentation and coherence of international law. And this is Yaqanni Alay, which is thank you in my mother tongue. That's the end of my presentation. I thank you very much for your attention, and I give the word back to the prorector.
Thank you so much for your presentation. The opposition will be opened by Professor Kamperman-Sanders. Professor Kamperman-Sanders is Professor of Intellectual Property Law at our university, and he's also the chair of the Assessment Committee.
Thank you, Mr. Pro-Rector. Dear candidate, I would first like to compliment you on your book. It's encyclopedic in nature, and even if I had to read it out of necessity, I found it extremely readable and interesting. There was so much depth and pleasure in reading this. Thank you. However, I would like to query you on an issue, not surprisingly perhaps, to intellectual property and policy freedom. To be more precise, the concept of necessity in Article 8.1 of the TRIPS Agreement, the recent patent waiver on COVID-19 vaccines also being brought in this light, the linkage to Article 7 of the TRIPS Agreement, stating that intellectual property rights should contribute to a balance of rights and obligations, which you also alluded to, and how to square this concept of necessity with the proviso in Article 8.1 of the TRIPS Agreement, reading, provided that such measures, policy freedom, are consistent with the provisions of this agreement. And here it goes. Like the waiver decision on the implementation of paragraph 6 of the Doha Declaration on the TRIPS Agreement and Public Health in 2003, before the 2022 COVID-19 waiver makes no reference to Article TRIPS and the necessity criterion at all. It rather refers to Article 31 bis of the TRIPS Agreement. And it would seem that in TRIPS disputes, the concept of necessity can merely serve to review domestic legislation as to consistency in the context of the relevant TRIPS provisions, nothing more. It cannot be used to juxtapose the other policy goals that governments may deal with to intellectual property rights. In fact, Article 8 legally does not amount to an overarching principle of higher ranking. And so is the concept of necessity in the context of the TRIPS agreement not completely neutered? And if so, why do you then state on pages 226 to 227 and following that necessity may in fact be of use in TRIPS agreement disputes, with direct reference then to GET 1994 and the GATT's general exceptions? Why is the issue of the provisos also present in one form or another in other TRIPS provisions, 27.2 on the exclusion of patentable subject matter, necessary to protect order public or morality, and Article 39.3 TRIPS, protection of undisclosed test data, that's what it deals with, also contains a necessity criterion. Why is this not further analyzed in your text? Now also, several panels have referred to Articles 7 and 8 of the TRIPS agreement. And then this concept of necessity is not present at all. For example, the panel in US Section 211 of the Appropriations Act simply talks about this balancing of rights and obligation as a good faith principle. And when we look at an analysis of Article 8.1 TRIPS proper in the EC trademarks and geographical indications case, the panel basically says that the principles reflected in the TRIPS agreement concern a fundamental feature of intellectual property protection, that it inherently grants members the freedom to pursue legitimate policy objectives, since many measures to attain those public policy objectives lie outside the scope of intellectual property rights and do not require an exception under the TRIPS agreement whatsoever. So, to what extent is necessity a criterion in the context of the TRIPS agreement and WTO law broader at all? I look forward to your reply.
Thank you, highly esteemed opponent. The context in which necessity is discussed in this dissertation is to find some sort of an organic meaning into the concept itself. But it is admitted that this necessity concept is presented in different formulations, not only in different agreements of the WTO, but also within an agreement, for example, the TRIPS agreement. In some of these articles that you just mentioned, necessity is presented as part of the overall TRIPS agreement, which means it is part of the substantive obligation, like the article that he mentioned where necessity, when a state takes an action out of necessity, it has to consider the other obligations of the TRIPS as well. But in some provisions, such as Article 73, for instance, security exceptions, there is no such obligation, because that is presented as an exception to the entire obligations under the TRIPS, although the preamble shows that the balance should always be maintained. Even in the GATT and GATS, the appellate body was very careful in interpreting necessity, that whenever it is interpreted, it must also keep in mind the rights and obligations, that is the right to take regulatory measures vis-a-vis the obligation to allow trade. So in this context, the purpose of mentioning TRIPS agreement is whenever a panel comes across one of these articles and it has to interpret this concept of necessity, what are the elements that it should take into consideration? So as it stands, whether it's in Article 7, 39, or 73, or Article 8, the understanding of necessity should be such that this member takes these actions in a way that will appear that it is contradicting its TRIPS obligations. But the specific article guides us up to the limit that this member can go. In Article 73, for instance, the focus is only on the necessary measure. But in Article 7, 39, or 8, the focus is on allowing this member to take these exceptional measures while maintaining the other obligations into consideration. Therefore, even within the TRIPS agreement, this dissertation admits that necessity can be presented in different forms, and that's one of the questions that needs to be taken. How is that concept presented? How is it formulated in that agreement itself? For instance, in the COVID case that you mentioned, or the Doha exception that reflected itself in amending Article 31 bis, the story shows us that members wanted to take action because of HIV, malaria, or now COVID, but they wanted to have some legal context or some legal justification. So the way the COVID exception has been granted, or the way the malaria, TB, and HIV exceptions have been granted, is not out of taking measures that are debated under one of these articles, but a sort of a global response to what has become in the form of a pandemic. So the context in which those exceptions have been granted is a bit different from a case like in this dissertation, where a member has to violate its TRIPS obligation and then justify it as necessary. And therefore, the purpose is to give some sort of a guide as to how a panel or the appellate body needs to look at the organic meaning of the concept of necessity.
Are you satisfied with the answer?
I have no further questions, no.
In that case, the opposition will be continued by Professor Fitzmaurice. Professor Fitzmaurice is Professor of Public International Law at Queen Mary University of London and also a member of the Assessment Committee. And I would like to welcome her very much to Maastricht University today. Great to have you with us.
Thank you very much. First of all, I would like to thank everybody for you and the Maastricht University for inviting me to this very important occasion. Thank you very much. It's very much appreciated. And I would like to say that I also enjoyed reading your erudite dissertation. And as a generalist, I have more general questions on necessity. So I have the following question. Is there a general concept of necessity in international law, considering its somewhat different understanding and application in various areas of international law? For example, is the concept of necessity the same in WTO law as in international environmental law? Do we have perhaps several concepts of necessities? If this is the case, what is the telos and usefulness of Article 25 of Articles on State Responsibility? And is it reflective of international law as it stands at present? Thank you.
Thank you, highly esteemed opponent. This dissertation is not looking at having one and same concept of necessity across all fields of international law. It admits actually, in fact, it wants to present these findings with the admission that there must be slight adjustments to each field of international law where necessity is presented. But sometimes the risk is you might have some areas such as the two areas that I mentioned, international environmental law and international investment law, where the practice shows us that those who decided those cases seem to have sort of a choice between Article 25 and then the WTO law concept of necessity. The same in international environmental law. The clearest example is the example of international investment law, where in the ICSID tribunals, some panels chose the Article 25, and then one panel, chaired by Giorgio Sacerdoti, applied the WTO law concept of necessity. And the result was Argentina lost in those previous cases and it won in this case. So this is the kind of risk that I try to put into a picture. This is the result because nations go there to win, or sometimes they can lose a case. And I believe that it is because of the choice of the concept of necessity that Argentina won or lost, because the crux of the debate was Article 11 of the Investment Treaty, which is the emergency exceptions. And in the case of international environmental law, although we have not had a case where a panel had to choose between Article 25 and the WTO concept of necessity that refer to the environment, Article 20B, for example, or Article 20G, but in the broader context of international environmental law, we have seen that, for example, in the Gabčíkovo-Nadžiramus case, the ICJ referred to Article 25, whereas in the disputes within WTO law, reference is usually had to Article 20B or the other articles that are related, in my opinion, to international environmental law. Although a debate within WTO law generally does not allow to make reference to Article 25, but because this is a debate in the general context of international environmental law, so if you look at it at the general perspective, we see that in some cases the WTO law concept of necessity is used, and in other instances, although all are international environmental law, we see that Article 25 is used. So Geneva uses Article 20B, and Den Haag uses Article 25. Although Gabčíkovo and the other environment-related cases in WTO are all parts of international environmental law. Therefore, the effort is to have some sort of consistency in the understanding of necessity, although there are some basic differences that cannot be done away with. For example, on text basis, Article 25 does not allow entertainment of alternatives. It should be the only measure available. And WTO law is a concept of necessity is essentially based on looking at alternatives. So you can't remove this. So it is admitted that there could be some difference such as this, but there are some other elements that can be brought together and cross-fertilized. Therefore, whether you go to Den Haag or Geneva or you go to Washington, D.C., what is meant by necessity is generally understood at some level of consistency. Yes, therefore, I admit that necessities are inevitable result of fragmentation of international law, but that should not lead us into, if I might say, some absurd results such as that happened in Washington, the exit tribunals. Thank you.
Are you satisfied with the answer?
Yes, I am.
Thank you so much. The opposition will now be continued by Professor Marceau. Professor Marceau is Professor of International Economic Law at the University of Geneva and also a member of the Assessment Committee. And I also would like to welcome her very much to Maastricht University today. And she is joining us online for this ceremony. You have the floor, Professor Marceau.
Thank you very much. I'm delighted to be with you, disappointed not to be with you in person. And I will start with 2 words of congratulation and then a question. Congratulations for having completed this thesis. Completion is always by itself sort of merits compliments. And as you may know, I personally like very much your topic, that is looking at the influence that one system or one concept can have to others. Although I have to say sometimes I thought that you were confusing influence generally with mandatory prescription by rules of interpretation. So for instance, all judges can read a book or a newspaper and get an idea that they will apply in a dispute. So I'm convinced that many other tribunals read and use WTO and vice versa. And I would encourage in that context that you look you didn't cite it, but I wrote a paper on the influence of the WTO dispute settlement concept in other systems that I called, a bit like you, a lighthouse in the storm of fragmentation. And this was in 2012, and it's impressive, the amount of other tribunals that have cited things from the appellate body, not on necessity, however. I have also some, I don't want to be negative, but in the context of publication, some issues about your review of the WTO Article 20 in particular. You didn't talk at all about the Brazil taxes and the US-China most recent case where values were extensively discussed, where development, for instance, was considered a value, or intellectual property. But my question today, because unfortunately I can only ask one, I had tons of them because it was a pleasure to read and sort of think of questions. My question refers to a comment you make at page 119 of your thesis about another author, Regan, and I think it touches at the heart of my question, where I would ask you, and my answer is no, but I'd like to hear you because I believe your answer is yes. In my view, or do you think there is a similarity between the so-called proportionality test and the necessity test in the WTO? And allow me just to read a little excerpts referring to Professor Regan, so the other people in the room follow me. You cite him as having said that the WTO weighing and balancing test contradicts the essence of an objective examination of weighing and balancing because of the WTO constant search for alternative measures. And here and also it continues a long time, because all WTO members have the right to choose their own level of protection. You say that in your thesis, but my question is the following. If a real, or at least European, an international law proportionality test allows the judge or whoever is reading to suggest in conclusion that a measure is too restrictive or too causing too much damage to others, and therefore the level of protection should be reduced. Isn't there a fundamental contradiction with the WTO system where the judge cannot tell a party that the appropriate level of protection, if you want, under SPS, or X level of protection that it considers is its own at the level it considers good? It may not be able to maintain the measure, but in WTO, you cannot challenge the level of protection. So as noted by Regan, where he complains that the WTO test is incoherent because its premise is that he reads necessity the way I think I explained it. How do you explain this? Any sort of parallel that could be made between the so-called traditional proportionality test and necessity test? So I limit to that question for now.
Thank you, highly esteemed opponent, for your comments and question. One of the challenges that I had from the beginning of my dissertation was to find where did this interpretation of necessity come from. In fact, I had a moment with my supervisor, Professor Peter van den Bosche, where I told him, it is now appearing to me that the first interpretation of necessity is like the Big Bang, because you do not see in the first case was necessity was interpreted, the 337 case, you have this paragraph that comes from nowhere and interpreting Article 20D. So I tried to trace the origins of of that paragraph, because that is the paragraph that has been built upon to lead into what we now have, the concept of necessity, although the WTO concept of necessity is completely different from the GATT concept of necessity. So that led me to the only option that I had. It was to look into the background of the three panelists who first dwelt upon that case. And same with the panelists who first formulated what we now have, the WTO law concept of necessity, because even in the Korea beef case where they have this paragraph, it just simply comes into the picture. So I thought maybe this has to do with the background of those who sat there. So I did that, and the conclusion that I had, and I even cite an article by two professors who wrote an article and then a book, who are quite confident that the reason could be because of the background of at least two respective panelists who came from the proportionality thinking in the European court system. So we have Judge Pescatore, and we also have Professor Ellerman. So I interviewed people who worked with them, who were quite confident. Professor Peterschmann, for instance, who told me and even asked me to quote him as saying that Judge Pescatore drafted that paragraph himself, and he would not let anybody else touch his drafting of a report. But regardless of this, I link the concept of necessity in WTO law with the proportionality principle in the European court system. I refer to writings including those by Professor Van den Bosche, where I compare the concept of necessity in WTO law and the elements of the proportionality principle in the European system. And rightly, as my highly esteemed opponent identified, that element of considering the effect of your measure is found in the European system in the form of the fourth element of the proportionality test, like the cost-benefit analysis, which we do not find clearly, I say clearly, in the WTO system. But there are some writers, and I'm convinced that they are correct, that even though not latently written there, for example, in Article 20, the chapeau might be read in such a way as to sort of balance or limit the extent of the protection that the respondent chose. There are some considerations that the respondent must keep in mind as it applies that measure. So I make this say half-hearted suggestion that could this be a reflection of the proportionality principle in text? So necessity, when it was interpreted, did not have a textual basis. It simply was interpreted out of the word necessity in the paragraphs. But the chapeau gives us a text to guide the limit of the application of that measure. So although it is not clear that there is no obligation on the respondent under WTO law to limit the extent of the measure that it takes, but could we take the chapeau as some sort of a guide as to the extreme that that member can go? Therefore, we cannot say that the WTO law concept of necessity reflects the proportionality principle as practiced in European courts, at least, but you see some commonality there, and the link could be these two people who worked there, or it could be the general understanding in that context. Regardless of that link, however, what we now have in the form of a consistent practice of WTO law and European court system that interprets the concept of proportionality, that is the only link that I could not find. I cannot boldly say that the WTO law concept of necessity considers that fourth element. But I make a suggestion at the end whether this can be taken into consideration. However, because Article 20b, or those are paragraphs in Article 20, serve as some sort of an autonomy that members have to regulate as part of the sacrifice they are making to be consistent with WTO law, maybe we can say that that part is left out, the part where they should consider, because they have other considerations under the text of the GATT or the TRIPS or other provisions of the WTO law. Maybe that can be the sort of the balance that is tried to be reflected. So I agree that they're not exactly the same, but you see some reflection of European law in WTO law.
Are you satisfied with the answer?
Not fully, but I will. I do not disagree with the points made that if you had, for instance, pescatoria or element with European education and background, of course, this influenced their thinking and allow them to possibly integrate and invent things. To me, this is different than a formal sort of similarity, but I think the candidate makes it clear that he's really making efforts to draw parallels rather than saying one copied the others. And to me, and I'll end with that, it makes sense. WTO is much less integrated than EU law. And for an EU judge to tell in a conclusion, you must reduce the level of protection, or you can do this and that, these sort of conclusions don't exist in WTO. The WTO judge, the conclusion will be your measure is consistent or not, but never would they dare. They may talk about the effect on others, but challenge the fundamental right of WTO member to determine their level of protection, even if they're not able to implement them ultimately because it's too high. But thank you very much, and congratulations again for completing the thesis and for the choice of topic, because coherence is the future.
Thank you so much. Now the opposition will be continued by Professor Lijnzaad, who is Professor of the Practice of International Law at our university and who is also a member of the Assessment Committee.
Thank you. Good morning, and thank you very much for presenting us with a big book that looks very pretty and which has taken you a lot of time, I'm sure, to write such a broad discussion of the concept of necessity. I think that is very impressive. You take us through many chapters of public international law, and you add a number of interesting historical sideways background information to that. Now, on page 287, you refer to the Rainbow Warrior case, and you present this as a landmark case in the development of the contemporary thinking about the concept of necessity. Then in your chapter 5, where you discuss lots and lots of case law, the Rainbow Warrior case again appears, and I was struck by its appearance in the list of case law, in the sense that you go through case law from the Permanent Court, then you go through case law of the International Court of Justice, and then there's one case from the Tribunal for the Law of the Sea. That's also, of course, very relevant. But then we get to the Rainbow Warrior case, and I was thinking back to what you had mentioned earlier, positioning the Rainbow Warrior case as a turning point. I think this is how you describe it. And I was wondering, why is that the case? I think many contemporary students wouldn't remember this case. However, it involved a Dutch ship, and there was a Dutch national who died. And it is an odd situation, after all. It's not only the fact of the explosion in the harbour of Auckland in New Zealand, but also what happens after that, referring the case to the then Secretary General of the United Nations, which I've always felt was a bit of a 19th century approach to the whole matter. And then gradually you see that France, under the guise of let's say, medical situations cast as urgency that eventually end up being necessity, are able to make sure that the two Secret Service staff members return to mainland France. Isn't that wonderful? But why, apart from all this wonderful gossip and the story behind it, why is it a turning point in your thinking? What is so important that this case, which is of course not from one of the main tribunals, why is that a turning point? I had some difficulty understanding that. Also because I would say that by now the case is, I'm not saying really forgotten, but it's hardly prominent anymore. I very much like to hear your thoughts on that.
Thank you, highly esteemed opponent. The Rainbow Warrior case is presented in the context in chapter 5 of the role of international tribunals in developing the concept of necessity in customary international law. So that is the significance of that case, not in the general sense of developing the concept of necessity, because the 4 chapters before that showed that other tribunals, texts, and others had contributions. The reason why this case is so important in that narration is because it achieved a couple of, it presented a couple of ideas that I found very interesting in clarifying the concept of necessity. First, it is for the first time that we see clearly in a tribunal's holding where necessity is distinguished from force majeure and other concepts of necessity, because there was a conflation of these concepts in previous tribunals, including actually the Permanent Court of International Justice. It seemed that those previous tribunals, for example, the ICJ in Corfu Channel case, even one of the judges said, we don't have a concept of necessity in public international law. But this tribunal not only recognized the concept of necessity, but also distinguished it from, so it gave it some sort of a clarity. Because in previous tribunals, you see that even in one paragraph, they refer to necessity, and then the next line refers to self-defense or self-preservation. So you get confused, because in the 20th century, at least, we should have some confidence, given the flow of history, that necessity is distinguished from the other defenses. So even judges, the members of the rapporteurs of the International Law Commission refer to this case as one of the cases which they refer to for formulating Article 25 of the RCOA. The second most important contribution of this case, and I found this only in the Rainbow Warrior case, is that this tribunal made a distinction between necessity as applied as primary rule of international law and as secondary rule of international law, which are two of the most important concepts in developing this thesis. Because one of the questions that needs to be taken is to make sure that necessity is distinguished from other concepts, but also to make sure that you consider the formulation in which it is found. For example, in WTO law, necessity is tailored with the substantive obligations. It's part of the substantive obligation. But in customary international law, it comes when you have the consequences of, say, breaching the primary rules. And I found out that this Rainbow Warrior case helped build my thesis into a level where I can say customary international law was really served by the opinion of this Rainbow Warrior case. And Professor Roberto Ago also makes a lot of reference to the Rainbow Warrior case.
The opposition will now be continued by Dr. Núñez. Dr. Núñez is university lecturer at the Faculty of Law of our university. You have the floor.
Well, first of all, I'd like to commend you for a very well-written thesis. Also, to follow up on Professor Mansour's comment for the choice of the topic. It's a very interesting topic, and it's very courageous to actually address it in such a way. And my question, in fact, has to do basically with your engagement in this, what has been termed recently, this form of comparative international law, right? So you have not only compared the way the different ways in which states look at the concept of necessity, but more specifically at how different fields of international law have done that. And central to your exercise is the concept of interinfluence, right? So in chapter 6, you generally look at the concept of necessity in the WTO law and how also it has developed through customary international law, and it is represented by Article 25 of the Articles on the Responsibility of States for International Wrongful Act. And I'd like to ask you perhaps to further clarify, what do you understand as being interinfluence? So at some points you refer to cross-fertilization. But I'd like for you to eventually further elaborate on what and how do you measure such interinfluence. To give another example based on something that you've recently spoke about, international investment laws, so basically arbitral tribunals, are said often to borrow the concept of necessity from WTO law. But in some cases, in most cases, they do not apply the WTO necessity tests. So how do you effectively measure this type of articulation and interinfluence between these different fields?
Thank you, esteemed opponent. I try to consistently use the term interinfluence. In fact, I wasn't sure even if I could use this term, and I had to check it online whether this word actually exists or so. Cross-fertilization is used in another context. I only refer to it while citing some other writings. So I did not want to, because it is used in a broader sense of, say, the relationship between different fields of international law. But this, although it is part of fragmentation coherence, this thesis refers to a singular concept that is found in difference. So the coherence sought here is this concept in different fields of international law. So no effort is being undertaken to cross-fertilize the different fields of international law that are affected by this customary international law and WTO law. That would be beyond the scope of the thesis. But what this interinfluence tries to do is to recognize differences, inherent differences, but also not to sit idle while more can be done to bring these different concepts of necessity into some sort of a line. And the highlight of the thesis is the Argentina tribunal cases, where the panels seem to be at liberty to choose. In fact, you do not see a lot of debate by Argentina or the claimants as to why this panel should pick this definition of necessity or that definition of necessity. My opinion is that the choice of necessity led partly to the result that we had. And then Professor Sajardoti, who I believe had a lot of influence in that panel, followed up with an article after that case where he defended their choice of the WTO law concept of necessity. Including in that panel, they tried to justify why they picked the WTO law concept of necessity. Seems to, because that case came after a series of cases that applied Article 25, and they seem to be cognizant that this is not correct. Therefore, they try to justify why they pick the WTO law concept of necessity. The text looks like Article 20B, Article 20 of the GATT. The context is closer to trade v. investment than customary international law v. investment. And then, quite interestingly, at the end of that tribunal, they make something that is interesting. Although they're referring to WTO law concept of necessity, they include one element that is not found in WTO law concept of necessity. There they said, we are going to examine Argentina's contribution to bringing up this disaster. You find this concept in Article in RCY. You don't find it in WTO law. WTO law does not examine the contribution of the respondent to bringing about that case. So this inter-influence, in fact, at the end of that chapter, I say, how about we include this concept in WTO law concept of necessity? Would WTO law concept of necessity be served by taking into consideration? I just simply ask and do not provide an answer. So this inter-influence is some sort of an exercise into allowing some elements to be interbred between these concepts and see if, and I found out that the customary international law concept of necessity can be, my comments are that these recommendations do not affect the text of Article 25, because the ICJ, in interpreting Article 25, included some ideas that you don't find in that text. So how about we bring some of these interesting elements from WTO law? So it is in this context that I try to look at inter-influence.
Are you satisfied with the answer? Yeah. In that case, I was very happy to hear that Professor Marceau indicated that she has many questions for our candidate. So I would actually like to invite her to raise still one of those questions that you have. Professor Marceau.
Uh, 54. Yes. 354 in your thesis, and it's about all this debate and exchange that I have had with Professor Paulin, but then it's your summary of, you say there is a general consensus, or there appears to be, that WTO law is open to being influenced by other fields. Well, no problem. And then you reach some conclusions. If WTO law explicitly contracts out non-WTO rule, non-WTO law, unless explicitly referred to in WTO, cannot be enforced. And here's my question. You write, non-WTO law may be referred to for other purposes, such as interpretation, and that's my question. What do you mean? You write, and insurance compliance of the acts of members with their obligation under WTO agreement. What do you mean by saying that using non-WTO law for ensuring compliance with WTO law when these non-WTO law terms are not explicitly mentioned? What do you mean ensuring compliance with WTO law? How can a judge ensure compliance or an assessment?
Thank you again, highly esteemed opponent. These remarks were made in the context of building the case where WTO law is part of international law. That is the background that led me to the more detailed analysis at the end, where I discuss whether WTO law is lex specialis to RCY or what have you. So as I build this story that WTO is definitely part of public international, because you know at the beginning there were some doubts whether international economic law is part of, although that is history now. So there are these references where one area of public international law borrows concepts from other parts.
You may briefly conclude your reply.
Okay. So it is one of the practices in public international law where you refer to another public subject of international law to confirm in the context of international law that what you're doing is right.
Okay. Confirm is fine. Thank you.
Thank you. Senai Andemariam, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company, both here and online, await the results of our deliberations and our return in this room.
The short long wait begins. Thank you very much. Very well.
The PhD defense has now ended. The degree committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes. In the meantime, let's take a closer look at Maastricht University's renowned teaching method, problem-based learning. Once the prorector reconvenes the session, we'll tune in and continue the live stream.
Problem-based learning, or PBL. What does that mean exactly? 3 of my fellow students and I will show you around. Every week, we analyze a different case or issue together. We discuss the case and everyone can contribute different perspectives to the group discussion. If we get stuck, our tutor helps us out and suggests what we could do next. I prefer going to the library to prepare. Here, I can focus and I have quick access to books or journals that help me understand the case. Today, I can also train my stitching skills in the Skills Lab, where you can immediately put into practice what you've learned. After a day like this, I like going to the gym to clear my head and get ready for the next day.
At UM, you meet people from all around the world. Hello guys. Some of them are doing their exchange semester here, and they often say that PBL helps them learn and retain things very easily. I can understand why. It's a very active way of learning because you have to bring your own perspective to real-life cases. You have a lot of freedom to manage your time, your studies, your hobbies, and your work. Of course, that also means a lot of responsibility. Right now, for example, I'm arranging my exchange semester in Madrid. How cool is that? In this group session, we're the managers who have to allocate the resources of a real company. This is how we put into practice what we learned this morning. Studying here means being proactive and learning to plan well. Prioritizing and performing well under stress are great skills that help you develop as a person. But now, it's time to grab a coffee at the Student Service Center.
Right now, we're at the Brightlands Camelot campus. Here we can apply knowledge from lectures and tutorials in a practical setting. This helps us understand what we have learned and further develop our lab skills. Today, we're determining the amounts of cholesterol in various products. What I really like is the project periods at the end of each semester, where we complete a full research project that includes planning, collecting data, analyzing, and presenting the findings. That way we learn how research works and we're able to see what it's like to be a real scientist. After practicals, I have to write a lab report that also helps me process everything I have learned today. UM has a lot of learning spaces where you can work on your own or with other students. This evening, I'm meeting my friends for a movie night organised by the MSP Study Association.
If you study law, you have to read quite a lot. Not all information is relevant, so you learn how to easily find the information you need to solve your case. In the afternoon, I have to give a presentation, so I like to practice it with a fellow student. Later today, a lawyer is giving a lecture. This will help us better understand the case we're working on. Speaking in front of a group is quite exciting the first time round, but you get used to it quickly. And having to present helps you also to adopt knowledge better. What I like the most is that we sometimes get to enter a plea in front of a real judge. These moot courts are really exciting. Now it's time for drinks with friends. Studying is important, but so is relaxing once in a while.
Hi, today we'll talk about sex and gender. Two words which are often used interchangeably in research, but however have separate meanings.
In this video, we'll talk about the difference between sex and gender, why it is important to account for one or the other in research, and how to do it.
Okay, let's start. What is sex and what is gender? Sex is assigned at birth and has mostly to do with physical and physiological features such as having XY chromosomes or having a uterus. While gender relates to your experienced or constructed identity, the way you feel about yourself. It is important to know that for some people the gender identity might not always align with their sex assigned at birth. Concerning sex, there are three options: male, female and intersex. The most common genders are man and woman. A majority identifies as either one of those. But there are many other genders next to man and woman, and sometimes people identify as both, or as neither man nor woman, as they might identify with another gender. Furthermore, people's gender identity can be fluid. This means that the way they identify themselves can change over time. Gender identity can be very personal, and everyone can have their own interpretation of their gender identity.
But why do we need this distinction in research? Sometimes in a study, you want to compare the results of two groups and see if there are any differences that are relevant to know. It is important to ask yourself the question, do you want to know the biological differences or some behavioral differences? For some studies, it is relevant to know the biological differences. For example, symptoms of heart attack can be different for males and females. And for some studies, it is relevant to know the behavioral differences. For example, do the same kind of advertisements work well for people identifying as men or women?
So, how can we more accurately account for this in research? We would like to give you some hands-on tips for how to use the words sex and gender right and to make your research more inclusive. First, if you want to address people in general, you could be more inclusive and use participant or reader. In Dutch, beste deelnemer, lezer.
Second, ask yourself, is it necessary to obtain this type of information? What do I need it for? And how will I use it? Not every study benefits from collecting data on sex or gender, so then you should not include these questions.
Third, if for your study it is relevant to know more about the biological sex, you might ask, which sex was assigned to you at birth? Or in Dutch, welk geslacht is jou toegekend bij je geboorte? Don't forget to include the option of intersex.
Fourth, if you're more interested in behavior, you can ask the open question, what label do you feel best describes your gender? Or in Dutch, welk label beschrijft jouw genderidentiteit het beste? And leave the answer options open.
But note, when asking for someone's identity in closed format, you should always add the answer options, not listed namely, and I'd rather not say, or in Dutch, niet genoemd namelijk, en zeg ik liever niet. It can be a sensitive question for people, since discovering your identity is not always a straightforward process.
We hope to have given you some new information and tips on how to make research more inclusive. This video was brought to you by UM Pride. Feel free to reach out if you have any questions.
Senai Andemariam. The degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Your supervisors, Professors Van den Bosse and Prévost, are authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
Do you promise to work in accordance with the principles of scientific integrity at all times, to be careful and honest, transparent, independent, and responsible?
I promise.
By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Senai Andemariam, the degree of doctor. And grant you all rights attached by custom and law. As evidence of this, I now present you with a degree certificate signed by the rector, the secretary, and the other members of the committee, and affixed with the official seal of the university.
Dear Senai, here we stand. The nice thing about giving a laudatio is that the person giving the laudatio is the first person that may name you with your new title, Dr. Andemariam. We have come to the end of a long journey. A long journey, if I'm not mistaken, it started in 2013, and which we have now successfully concluded. It has been a journey, like many other journeys in life that are worthwhile undertaking, with ups and downs. But there was never any doubt in my mind and in the mind of Denise, your co-supervisor, who has undoubtedly been of much more help throughout these years than I have been. There was never any doubt in our mind that you would make it to the finish line. Throughout the period that you've worked on your doctoral thesis, you've always had a very heavy teaching load and also very heavy administrative tasks at your university. You also published a number of articles, and on a wide range of topics, including one, and actually it's probably not the only one, but including one on, I have to check my notes because I couldn't quite believe, on Bible translation efforts in Eritrea. An article that was published in the Journal of Translation. So, wow. Your work on your PhD was made possible by generous scholarship, a scholarship from the National Higher Education and Research Institute of Eritrea. And that scholarship allowed you to spend considerable time here at this faculty, at this university, but also, and I fondly remember that, at the World Trade Institute in Bern, and in Geneva, where you interviewed many of the people that are guilty or not of some of the developments in the case law on necessity. And I envied you actually that you got to talk to all these people, but we find in your book the reflection of what they said. I also remember a dinner that we had in my place in Geneva. I remember that dinner for various reasons, but it also, I also remember it because during that dinner, I got to learn you better as a person. We had been in contact before, but it's at that dinner that I got to know you and your family, your children. You had pictures of them, and that made it very, very special for me. You have chosen a very difficult topic, a conceptually very difficult topic for your thesis. And I think you've heard the members of the assessment committee today, the degree committee today, you've heard them compliment you on even on that choice. I was very happy with the choice of your topic because necessity is one of these things that really excite me, as it excites you and as it excites many of us. It's a very important concept, not only in international law, but in law in general. I want to, as others did, congratulate you with the final result. It's a very, very, very fine book, and we heard an excellent defense. I'm confident that a great future awaits you, either as a legal scholar or in another capacity in your native Eritrea. And I hope, and I express this wish, both on behalf of Denise, of myself, and I'm sure of the University of Maastricht, that we will remain in contact in the years to come. Again, congratulations.
Thank you. Dear Dr. Andemariam, also on behalf of the Board of Deans and the University and the Faculty of Law, many congratulations on the degree that you just acquired. I find it really wonderful to see that a colleague of the School of Law of the College of Business and Social Sciences in Eritrea is doing his PhD here with us at Maastricht University. Let this be the beginning of a wonderful friendship between our two faculties. Many congratulations also to your family and friends, both here and watching this ceremony online. And also many congratulations to your supervisors. I'd like to thank all the members of the committee present here, in particular also our members from outside of Maastricht University, who are here with us today, Professor Fitzmaurice and Professor Marceau. Many thanks for your participation in this ceremony. Before I officially close this session, I want to say that we are going to take the traditional photo of the young doctor, together with his paronyms, together with his supervisors, and with all the members of the committee, including Professor Marceau, who will also be on the photo online, because we have you here, you cannot see that. We have you here on a very big screen right behind the young doctor. So we're going to take that photo right here in the aula. And with that, I close this academic ceremony. Okay.
Maastricht University would like to extend warm congratulations to the PhD candidate and their supervisors on a successful PhD defense. Thank you for joining us. Thank you for watching.